Now, having looked at this text earlier in the earlier episode where I explained some of it, I'm going to go now into details in analysis as to what are the things that are important and to look at and identify in the text that we have seen. And you can see here, again, I am just trying to sort of repeat myself in a way, and say that we see that the lexical features that are used in the text that I read earlier in the previous episode of legal translation, that there are some legal adjectives like the word guilty and penal, and also number 2, terminology, jurisdictional and penal offense. And we can see there is also one of the features, lexical features of legal language is repetition of lexical items like penal offense and guilty and everyone. And that is to avoid any ambiguity in the legal text. Then number 4 is the use of legal expressions such as innocent until proven guilty or proved guilty, which are words that are used as well in Latin and of French origin. There are quite a few words that are used in the text, like distinction, for example. And there's also phrases, set phrases, like set forth, without distinction of any kind, on the basis of, or and on account of. And then finally, the adjectives that are multiple adjectives being added in order to be inclusive. The text will be inclusive, describing the country or the territory as much as possible as being independent and trustworthy and non-self-governing. Then we look at not only lexical side of the lexical features of that text that we have just come across and I've explained to you, but there are other features which are related to grammar or syntax. For example, we noticed that there is capitalization in the word or in the term declaration, and that is to indicate that it is a legal document, that the declaration is an actual document, and that's why it's a D capital. And then we have noticed also the use of modal verbs or verb, shall, being used more than once to indicate that it is obligatory and binding and not to refer to the future tense. And there is also the abuse of nominalizations and passive constructions. All the rights and freedoms set forth in this declaration, and without distinction up to the words or other status. And then number 4, we find that the sentence is a complex sentence. All sentences that we've seen are highly complex. They are full of clauses, such as in the sentence that starts with furthermore no distinction, with a relative pronoun to which a person belongs. And then it carries on and it says, and the clause where it says whether it is independent up to the word sovereignty. So there are quite a lot of complex sentences with a number of clauses in them. And number 5, as a feature in the syntactic and grammatical features or sense, is sentences are usually long and thinly punctuated, except for when enumerating. In other words, when counting things, like for example, when it says race, color, sex, religion, language, religion. And in the passive constructions that I have mentioned, there are lots of them. Examples: is held, be made, be held, and is committed. So these quite are very, very common because they are trying to be objective and they don't want to give responsibility to the because when you use passive, the pro-agent, which stands for the subject in the passive voice, is actually taking the responsibility. So the responsibility is shirking towards the pro-agent in the sentence. And there is number 7, which is the excessive insertion of post-modifying elements. In other words, lots of phrases, such as without distinction of any kind. And it carries on and says, such as blah, 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 blah. It carries on. And then it says, according to law in a public trial. And then it says, under national or international law. These are post-modifying elements. Again, another additional post-modifying element being inserted is at the time when. It carries on right to the end. There's also, you notice, there are hardly any adverbs being used at all in that text that we have looked at earlier. And there is also a lack of pronouns, except, for example, the use of it. Of course, this text that I showed you, which I would consider text A, it has violated the language, the legal language, by using the pronouns he and his, as in he has had and his defense, which should not be used in formal legal document and should not be used at all. And finally, in terms of the grammar and syntax, we have the violation of, or the error in not completing the last sentence when it says nor shall heavier, and then did not complete that sentence. If we are looking at the third type of features, because there are 3 features, as you've noticed, that we talked about. The first feature was lexical, the second was syntactical, and now we are talking about textual feature of the legal documents. And in the textual feature of the legal documents, you will find that the textual features are here. There are 3 of them, which I can actually then identify. The first one is the register, and that is the use of formal language. There is some archaicism or archaisms, and they are seen in the words that are used from a French or Latin origin, such as constitute, commit, presumed, guarantees, penal, and offense. And also notice the word guarantees and guarantor, and employee and employer, and trainee and trainer. This is very common also as a use which is the ending E and ER and OR, guarantor, for example. And there is number 2, the legal language, which is full of law and legal instructions. Any act or omission. Sometimes act means law, and also under national or international law. In other words, it's under the national law of that country or under the international law in general outside that country. That is applied internationally, the law that's used by, for example, the criminal justice court in La Haye, in The Hague. And there's also the instructional language being used, and its text type. That is the legal language or the text, in that it provides regulation through instruction, as Bas al-Hatem at one time says, which is usually used in legal, governmental forms, to be used in courts, to be used in departments or in ministries, particularly in its negation form as well, or construction. No one, nor shall, no distinction. And all of these negations that are used, of course, this negation is related to grammar.